we have a court reporter? Well, that's it. Yeah. You want to do it that way? We'll run the table or now?
I'm sorry, what? Oh, sure. I'm Rob Weinberg, Attorney General's office. I advise the court. You guys want to sign?
So, Dr. Greg Miller, acting sheriff.
Yeah, we can't hear you at all.
I'm the Paris board member.
Ed Stanley, Physician Assistant Board Member.
I believe that's a good. Good.
This is being recorded now. I'm sorry, sir. I'm going to ask you to find a place and just, this isn't something open, this is a hearing. Everybody get comfortable.
So right now we're waiting for Assistant Attorney General David Abrams. Go on without him.
Do I just off it?
Are you folks proceeding with the matter, Dr. Joseph? Because if you want, I'd like to place something on the record before you guys do so.
I think we're going to wait for Dan Abrams to come.
I'm sorry?
Should we wait for Mr. Abrams to appear?
Well, I don't know.
Let's give him a few more minutes.
I agree really with you. So if you guys haven't started, that's fine.
Yeah, okay.
That's fine. That's fine.
If we have not started, is it, are we allowed to address the board? Mr. Chairperson?
Technically, it's not what we're here for. We just have to answer one question. It has to do with this, with the AG's asking us to answer. So we prefer just to wait because what would happen is if we opened it up for that, then we had to just need to stop this as Mr. Abrams comes in. Sure. There he is.
Representing you guys?
Did somebody give up a chair for Mr. Abrams?
There's a chair right there.
Okay, are we ready to start? You need a few minutes, Mr. Abrams, or are you ready to go?
I'm ready.
Okay, so.
Sorry, I'm late.
No, okay. That happens. So this is the Board of Allied Health Examiners. It's about 8 minutes after 6, July 23rd, and the hearing has to do with Dr. Joel Joseph. Everybody's been introduced already. And our hearing officers, Mr. Cisa?
Yeah, my name is Benjamin Sisson.
Okay, great, great.
And so I'm serving as the hearing officer for today.
Okay. All right then. And so the first order of business that we'll go into is there's been requests for recusals. So do you want to do that?
Well, Mr. Lujan, that's your motion.
Yeah.
Address it.
I believe, yes, that there's two pending, rather declarations asking for recusals. And the declarations do state the basis. In fact, you know, on the two pending declarations, one, rather, I believe Ms. Linda Perez is the, is the one that's mentioned twice.
Excuse me, Mr. Lujan knows that I respect him and I hate to interrupt. But as a procedural point, this is a meeting called for one purpose and one purpose only. I think it's, I know he's filed, there have been some of these declarations filed. That's not on the agenda. That's not part of this purpose of this meeting. So to allow this meeting to morph over into items which were not part of the reason for calling this meeting, items that were not on the agenda, that can wait until the hearing on the merits takes place. But any other subject other than summary suspension is not on the table for tonight. So with all due respect to Mr. Lujan, I think as a procedural point, we just, we're not able to entertain his argument and the declarations at this time for this special meeting.
Hold on, Mr. Abrams. I'm going to ask y'all to move away from me, please.
Give some space, please, and some professional respect and courtesy to our board members and the hearings folks that are here. Thank you.
Could I respond to that?
Yes.
Since first of all, then, it was the board's counsel that asked. Secondly, it's rather late, for you to be raising this so-called that it's not on the agenda. And because I believe 2 weeks ago when this matter first came before the board, two of the board members did entertain the motion and did recuse themselves. In fact, one did voluntarily recuse. The other one, you're the one that insisted that she recuse herself. So it's rather late for you, to now be saying that we should be entertaining that. And not only is it late, it's rather hypocritical for you to be saying that we shouldn't do this and we should proceed with what we've got and make a decision. And if the members are found, let's say that, should have disqualified themselves, then you know what, it's okay. So, but I believe that in the interest of economy, whether it's judicial economy or board economy, that the issue should first be resolved. Okay, so that's one. The other, I do have other issues that I want to bring up. For example, your competency to sit
Excuse me, we're
as the
only
lawyer
addressing
here.
Mr. Lujan, Mr. Abrams, my advice to the board right now is to go ahead and entertain the motion to disqualify. It's been sitting there since the last time we met. Since he has to adjudicate the summary suspension anyway, it's appropriate that the board determine whether they're qualified or need to disqualify themselves.
Well, may I respond to Mr. Lujan? I believe that on questions of law, we have a hearing officer, and board counsel is certainly entitled to express his opinion as to what he thinks the board should or shouldn't do. But we're lucky to have a hearing officer on matters of law, and I think it's within the purview of the hearing officer function that we have a ruling on this, or at least he could advise the board as to what he feels the right legal determination of Mr. Lujan's argument is. But to respond to Mr. Lujan, he's absolutely right. Mr. Lujan is absolutely correct that at the last board meeting, the subject of disqualification came up, and that was proper. I never made an objection at that time because that was a board meeting for general issues. That's not the case tonight. And it's true that I advised or I expressed my opinion as to whether certain board members should step back or not. But that's not why we're here tonight. It's not untimely, it's not late, because I already raised it. If Mr. Lujan had anything to say about disqualification, it should have been done at the last board hearing, or in fact, it can be done before there's a hearing on the merits, which, if summary suspension is entered, which I expect it will be, that has to be done within 30 days. So he had a chance last time. Tonight's not the night, and next time he has another chance. So I'm going to defer to the hearing officer as to whether he thinks the board should go into these side issues that weren't on the agenda for tonight or not.
Okay, the
First of all, may I respond? First of all, you are incorrect. Last meeting, the motion to disqualify was not, to certain board members as to general matters. It was as to Dr. Joseph's matter only. Okay, so you're wrong on that one. And we are here still on that same matter. And there was one declaration or motion that was filed that was not ruled upon last night. And that's the one that has to do with Dr. Miller, Mr. Pereira, and Ms. Harris. That was not entertained last night, unlike the other two. As far as I know, and I stood here all the time. So, so I just wanted to to clear the record, and that our objection, is not to whatever was on the agenda. It was to one particular matter on the agenda, and that has to do with Dr.
Okay, so
Just one word, Mr. Lujan. All of what you say is irrelevant because we're only going to consider at a special meeting what is on the agenda for the special meeting. And your disqualification argument is not on the agenda for tonight. And it would be unlawful for this, in my opinion, for this board to consider ancillary matters at this special meeting.
Okay, wait, okay. Now, what we'd like to do is defer to Mr. Sybil for his opinion on.
All right, I could give an opinion. I wasn't privy to the last meeting, so I could only give an opinion as to what my reading of the disqualification provisions in the administrative adjudication law. It simply provides that any party may request a disqualification of any hearing officer or agency member by filing an affidavit, which I assume has happened, prior to taking the evidence of the hearing. It does not say, however, that it has to be specifically on the agenda, so I think this board can consider it if they want to at this point. It's requesting disqualification.
Mr. Hearing Officer, prior to taking evidence is correct, and we're not here to take evidence tonight.
What are we here for?
We're here to consider summary suspension on the basis of the materials before the board.
Is the board going to be
Won't be any
making a
evidence.
decision on anything?
I'm sorry.
Is the board going to be making any decision on anything?
There will be.
Okay, and so is the board member that's being requested to disqualify himself or herself here today?
May I add, Mr. Hearing Officer, that we are here prior, this meeting is, a meeting prior to taking evidence, which would mean, that motion is, a relevant motion at this time.
What kind, is everybody going to vote in a decision? What kind of
But
decision?
we're not taking evidence tonight.
So
Prior
what's
to
happening?
taking evidence would be before the evidentiary hearing, which if they summarily suspend, has to be by law held within 30 days.
Mr. Simpson, the purpose of this meeting is to consider summary suspension.
Consider, will they be making a decision today?
Yes.
Then I
Without evidence.
Without evidence. How are
Without
they
taking
gonna be-
evidence, without any testimony, without any
So what are they
additional,
basing their decision on?
on the first amended specification of charges.
Just the pleadings?
That's right.
You don't intend to put on any evidence?
No, this is not an evidentiary hearing, of course.
And if I may be here, you see, last time, my understanding, and that's why I wrote a letter to Mr. Weinberg to follow up. My understanding last time was that the board was going to meet on the 23rd today, and the purpose was simply to analyze the charges, not to make decisions, to analyze it. That's my understanding, and that's why when the notice came out, I wrote a letter to Mr. Weinberg. My understanding is Mr. Weinberg probably has not received it, and perhaps it's because the AG's office has been moving. But I wrote that letter, I believe, Tuesday or Wednesday, and had that delivered to his office for clarification. So that's, so our position is that the notice that went out based on what occurred last week is really an incorrect notice, because that's not my understanding of what was to occur.
How many people here are you, have you filed an affidavit to disqualify themselves?
Well, we filed an affidavit, two of them are disqualified, so we don't need to address that. But, one affidavit for Dr. Miller, Mr. Pereira, and Ms. Harris, and then a subsequent affidavit for Ms. Harris alone.
So you're trying to disqualify 5 members
Well,
of the board?
We're not trying to disqualify anything. We're putting in what we believe, our basis for disqualification. And, of course, we're preserving our record. It's up to them what they want to do.
Two members of the board have voluntarily recused or disqualified themselves.
Okay.
Balajadia and Sybil Crisostomo. Mr. Lujan's motion to disqualify is corrected by the remaining 3 board members.
All right, well, the provision of law says if the disqualification would prevent the existence of a quorum qualified to act in a particular case, an agency member shall not withdraw voluntarily or be subject to disqualification. So if they get disqualified, will that change, would that affect the existence of a quorum?
That would leave us with 2.
Well,
Yeah, we would have no quorum.
You would have no quorum.
What do we have, 5 members or 4 members? I don't know. 5 members and 6 here. And what is the quorum? 4 or 5? I don't know, I'm asking you.
Those are the rules. I need to take a look at that.
What does it take to have a quorum of the board?
I know there's 9 members, correct?
Yeah. There's 1 missing.
So 5 would be a quorum.
Yeah, if there are 9 members, fine.
And so if we disqualify these people, would that end our quorum? Is my question. All right, well, the rules provide that they're not subject to disqualification. That's why.
That's been long.
Now, I do want to raise one matter again, preliminarily. I do not think Mr. Abrams is competent to serve as an assistant attorney general or to practice law in the territory.
I'm going to object to all
Well,
of this.
let me
This is a
finish. You can
personal
object.
attack
Let
on
me
Dan
finish
Abrams.
for the
It's
record.
not on the agenda, and he's filed no papers.
Okay.
He's filed no notice. He's way out of line here, and I object to any further talk about it. With all due respect.
I
to
am
Mr.
putting on the
Lewis.
record, so if I may be allowed to put on the record, you guys can do whatever you want, and Mr. Abrams can do what he wants. But, as the hearing officer knows, the purpose for a lot of these things is simply to create a record, so when it goes to Superior Court, the judge knows what occurred here. I took the deposition of Mr. Abrams last week, or 2 weeks ago. And Mr. Abrams, in his deposition, testified that he was admitted, to the cross-territory high courts around early 70s.
Have you filed something?
No, because we just learned this last week. We just learned this last week.
He's had a week to file
Mr.
something.
Abrams, Mr. Hearing Officer, if I can suggest that at the moment, we have nothing before the board, and Mr. Abrams is presumed competent. If for some reason we have something else that later, I can suggest you introduce it at that time. I think we need to move forward.
Well, first of all, I disagree that you have nothing before the board. You have me before the board mentioning it. Secondly, the presumption that he is competent, is a rebuttable one. And I'm, rebutting it through evidence that Mr. Abram gave under oath last week. And so,
Excuse me, only
and so
an
I want to put on the
incompetent lawyer would
record,
even
I
raise
just
this
want to
kind
put
of
on the
thing.
record, what are you afraid of, Mr. Abrams?
I'm not afraid
That's
of-
right, so
I'm afraid of
then,
wasting
so then
time.
allow me to waste my breath. Okay, I'm putting on the
Only an
record.
incompetent lawyer would
That's-
say these things. Don't you understand that?
Mr. Abrams was admitted to practice in the TT, he testified in early 70s. Came to Guam, was admitted, he says, in 74 through reciprocity with the TT High Courts. Well, however, and Mr. Abrams has not mentioned this, in 1978, Mr. Abrams got suspended for 3 years by the TT High Courts. And Mr. Abrams got suspended in the state of Florida as a result of the TT High Court suspension of Mr. Abrams in 1980. Now, Mr. Abrams was, suspended, subject to being reinstated, provided he takes certain, remedial steps. Mr. Abrams, to this day, has not taken that. So Mr. Abrams remains suspended
In Florida.
in Florida and the TT High Courts.
No.
Now, let me finish, please. Please.
That's
You'll
not-
get your chance.
That's not fair.
You'll get your chance. Mr. Abrams, so if Mr. Abrams is here, and he admitted he's never taken a bar examination except Florida, where he's now not admitted, that, if the basis that allows him to practice in Guam was because of his, admission in the Trust Territory High Courts and because of reciprocity, if that basis has now dissipated because he's been suspended and never been reinstated, then Mr. Abrams, who I take it has never reported this suspension to the Guam bar or to the Guam bar, then Mr. Abrams is not admitted, really qualified to practice law in Guam. Now you can say what you want.
I have a
Mr.
quick
Abrams.
question for the hearing officer.
Yeah, until the Guam bar makes an indication or the Supreme Court says that Mr. Abrams is not licensed to practice or competent to practice law, he's perfectly.
Well, I'm putting it on the record, and I believe that it behooves you folks to be aware that you may be wasting your time here. So,
He's
do
competent
whatever you
as of
want.
today, so
Thank you.
he could continue.
Okay, now the board would like to continue with the question
It's a
and
very good.
the request for a summary suspension of the license to practice veterinary medicine by Dr. Joel Joseph. So, the procedure B is that these orders about a little bit.
Hearing officer?
You were telling me there wasn't going to be any evidence taken.
No, but argument, yes.
Okay, so
Would we have given Mr. Lujan, for example, an opportunity to appear and be heard on behalf of Mr. Joseph? And of course, the disciplinary counsel, namely myself, is ready to make an explanation to the board as to why I feel the grounds are there to summarily suspend Dr. Joseph.
just based on your argument? Without
Well,
any
that's,
other
I'm not
evidence?
calling any witnesses or anything like that. The only documents I'll refer to are documents that are already before the board.
I don't think it's appropriate that the board make any decision without evidence.
No, may I be heard on that point? You see, the summary suspension, Mr. Hearing Officer, is very analogous, as Mr. Weinberg will no doubt say himself, very analogous to a temporary restraining order. The grounds for summary suspension are that Dr. Joseph presents an imminent threat to the community. And likewise, in a temporary restraining order situation, we're talking about irreparable harm. Both are temporary. In a temporary restraining order situation, we have a 10-day rule. In a summary suspension situation, it's still temporary, but we have a 30-day rule. And that rule is that upon summary suspension, a hearing on the merits has to be held in the nature of a preliminary injunction within 30 days. The law is clear on that. And the proposed order of summary suspension that I submitted definitely calls for a hearing within 30 days. So if the board believes that based on the materials before it, as is the court in a temporary restraining order situation, entitled to restrain or to enter a mandatory injunction in the form of a restraining order, this board has a similar power. And also, like a temporary restraining order situation, there's no evidence presented at the TRO signing. There's only argument of counsel, and that's exactly what we're going to do tonight. And it's entirely proper that there not be any evidence or witnesses or testimony. That comes later at the end of the 30 days when the evidentiary hearing on the merits has to be commenced by law.
But your argument is based on evidence, affidavits, is it not?
Only materials that are already before the board. I'm not going to submit any evidence at all, and I don't imagine Mr. Lujan will be allowed to produce any evidence that isn't already on the table.
Mr. Hearing Officer, first of all, at the last meeting, it was very clear because the board, I believe I got the feeling that the board wanted to go forward with the hearing that is, to consider whether some suspension was required. And if my memory serves me right, the advice from Mr. Weinberg was that it's going to take a long time because there's going to be evidence that Mr. Abrams has to present, and it's going to take, several evenings, and that's why it's scheduled for the evenings, and and so all that was discussed. So the fact that Mr. Abrams comes here without any evidence, really, it's his fault. He knows what was expected of him. That's number one. Number two, the summary suspension of a license is not anything akin to an order to show cause. In an order to show cause setting, what we're doing is simply we're saying the statute, we're ordering you not to do anything, okay? And you've got 10 days to come forward and show cause or tell me, the judge, why I should not continue with this order. In this case, the summary suspension, it's saying that you are barred from, working, from earning a living, and with all the people around you, like the employees, none of them, would be able to earn a living with you for 30 days, and then you've got 30 days to come, and appear, and put on evidence if you so choose. But in the meantime, for however long that hearing takes, and after that hearing, for however long the board takes to make a decision, he remains unemployed, and so do all his employees. So there's a huge difference. And I do agree with your analysis that, without any evidence, and let me go address Mr. Abrams, statement that he's basing it on documents that are with the board. Well, I'm sorry, I'm not the board. The only thing we have is the specification charges. There's no attachments to it. So, is it fair that we are here and that we don't even know what those charges are? And for your information, some of these charges really have absolutely nothing to do with health or safety for community. Some of them have to do with, for example, that Dr. Joseph resigned from his job in Fiji, and that makes Guam look bad in Fiji. Okay? Or that Dr. Joseph, said that this dog is this breed. And when this person took that dog to Minot, I believe Minnesota or someplace up there north, that there's a policy there that you can't have pit bulls there, and that this dog is a pit bull. Well, what does that have to do with the safety or the health of the community? Nothing. But in any event, the point is simply, and I agree with you, if Mr. Abrams wants a summary suspension, then earn it, Mr. Abrams. Put on evidence.
Let me go ahead and give you the provision of law regarding summary suspension, which is 10 GCA Chapter 12, 12210F. The board is authorized to summarily suspend a license prior to a formal hearing when it believes such action is required due to imminent threat to public health and safety. Okay, so that's the first thing the board has to consider. whether it will be an imminent threat to public health and safety. Also, it says here that the proceedings for a formal hearing should be initiated simultaneously with the summary suspension. Okay, so the law is pretty clear that it should be at the same time as a formal hearing and taking evidence. And even then, the board should consider whether there is a threat to public health and safety at this point.
Is the hearing officer, some of the
I believe
charges?
that the law requires a hearing to be set within 30 days for the hearing on the merits. And it says simultaneously, what it's talking about is the notice of the hearing, which has to be held within 30 days, not the hearing itself that will be held simultaneously with the summary suspension.
It says here, the proceedings for a formal hearing should be simultaneously. I see. You're saying that they could do it ahead of time and then set the hearing.
Well, what they have to do is either have the hearing day 1, day 2, day 3, or any day up to the 30 days, but they cannot wait longer than 30 days to set the hearing on the merits. But they don't have to have a hearing when they sign the summary suspension.
Mr. Abrams, why do you think that there's an imminent threat to public health and safety?
Well, I'm prepared to argue that, but I'd like the first issue settled before we go into this at all. And that is what we do tonight. And the only thing we do tonight is hear argument both ways from Mr. Lujan and myself on whether we should enter a summary suspension order. And if then set the hearing within 30 days of today. If that's what we're going to do, I'm ready to go forward right now.
Mr. Lujan?
First of all, Mr. Abrams has made presumptions when he says I'm going to argue. Because I'm not going to give dignity to something in which, we don't even know what the evidence is. He's got a statement of so-called charges, but we have no documents that back it up, at least, so that I'll be able to intelligently argue from those documents or to try and rebut what he says. But I believe that you are correct. Simultaneously must be given its commonsensical reading. Not a legal reading, but a common sense reading. And as far as me tomorrow, with English being my second language and understanding it, simultaneous means at the same time. Okay? Not Mr. Abrams has now retreated from his earlier statement that you summarily suspend him, give him 30 days, then we have a hearing in 30 days. Now he's modifying it to say, oh well, we suspend him now and we continue it tomorrow. We have the hearing on the evidence and day 2, day 3, day 4. So it seems that Mr. Abrams, as the wind shifts, his position also shifts.
The common sense thing is this, Mr. Hearing Officer and board members. How much sense would it make to have a full-blown hearing on the merits tonight and tomorrow night and however many days it takes, and then set the hearing on the merits in 30 days and do it all again? There can only be one hearing on the merits. And that provision of law in Title 10 that we just looked at provides for a hearing on the merits within 30 days after summary suspension. And it has to be set simultaneously with the summary suspension. Otherwise, we'd have 2 hearings on the merits, and that doesn't make sense no matter what language you speak.
Okay, ma'am, just a second. The hearing officer did ask a pointed question, Mr. Abrams. We need, as a board of members, to find out what is the imminent threat. So that's really where we would like to guide you to further discussions, is help us make that decision.
But the problem with that is they're just relying on argument without any evidence.
That's what you do in a TRO situation too, Mr. Jones.
That's not correct. With the TRO, you have a declaration that comes in, which is the evidence. You should practice TRO.
We have a sworn statement of charges
That's right.
here.
Well, no, not by the accuser, but by the party. You are the judge and jury here. By saying that your sworn specification is sufficient without anyone attesting that everything in those you know, all the allegations and the charges that you're raising in the specification are true. You know, you need an independent person to say that.
Well, I think the board members have expressed themselves that they're ready to hear what constitutes an imminent threat in order to make their minds up. I'm ready to go ahead.
I'm ready to hear it.
Mr. Abrams.
My recommendation is that if you're going to make a decision like this today, I think you should have evidence.
Okay.
Okay, yes, the declaration is evidence.
The declaration was filed with the First Amendment specification. It verifies the charges. So they're verified charges. Just like in a temporary restraining order situation, you'd have an affidavit. That's what we have here. It's totally analogous.
What I think this is just for fairness. If you guys making a decision like this, which is somebody's license, I do think that you should have a separate hearing. Perhaps if you want declarations from both sides, then you can make an informed decision that way. But I just don't think that it would be appropriate for one side to argue with declarations filed and no rebuttal when you're taking somebody's license.
But Mr. Season, he's had, I don't know how long, to submit whatever declarations he wants to submit. The only declarations he submitted are disqualification declarations. He had the chance to do that. He certainly had every opportunity before tonight to submit whatever kind of declarations in addition to that he felt he should submit, and he hasn't done it. So we have delayed this occasion to summarily suspend Dr. Joseph already, and I say we get on with it.
Mr. Abrams has got this, you know, I guess, upside down. We don't have the burden of doing it. You're the one that has the burden. That's right. And we don't have to file anything. You're the one that must prove imminent, you know, danger, you know, to health and safety, not us. So you're the ones that must come forward with evidence, and by way of like, okay?
No,
Not documents
I
that we
disagree
can
with that.
cross-examine. Not documents.
That's
that we
not a
can
hearing
cross-
on merits, Mr.
Well, that's the hearing officer.
Mr. Abrams, Mr. Lujan, hearing officer, the way I had been viewing this is that it would be evidentiary, and that's why we held it over from the last time we met. And that we would become.
That's what your impression was
That's
today.
what I thought we were doing. Now, it's difficult, but that it was going to be more in the nature of a preliminary if we're going to equate it. Even a TRO has a affidavits and declaration. There's some evidentiary support for a TRO. You would get that. So what I was thinking we were going to do was actually have some kind of evidentiary hearing on what you thought, Mr. Abrams, your strongest arguments would be as to why this license should be summarily suspended pending a full hearing on everything. That's what I was, and I think that's what the board was anticipating as well.
Well, there was a sworn declaration supporting the First Amendment specification of charges, Mr. Weinberg.
I haven't-
That is in the nature of how you file an application for a temporary restraining order with a sworn statement. So we did the same thing here.
I've reviewed the sworns, the verification of the specification of charges that's filed or signed by Brian Cruz, and I will advise everybody here that my view of that is that he's just verifying it, but he does not have first-hand knowledge of any of the allegations in the complaint.
But he does.
I don't think he even claims.
He says that he does because he investigated the charges. He interviewed the witnesses. He collected the exhibits. He was there when they searched the Wise House premises and found illegal controlled substances there. What other personal knowledge do you want, Mr. Weinberg?
Then I would expect him to be here so he'd be subject to cross-examination.
But in a temporary restraining order situation, I heard you just say that there has to be a sworn statement to support the application for the TRO. We've done that, Mr. Weinberg.
Here's the difficulty that I'm having with the specification of charges. I do not see from those charges something that jumps out at me and says imminent threat. What I think all the board would like to hear, let me finish this, what the board would like to hear is what you think is the imminent threat from you have a variety of charges in there. Things in Fiji I don't think is an imminent threat. You might disagree. But the board is interested to know what you think is the top critical issues that they should suspend this man's license for 30 days.
With all due respect, Mr. Weinberg, you're not a participating board member, and whether you think that First Amendment specification meets the criteria for summary suspension is totally out of order and totally irrelevant. Well, it's not a legal matter. It's not for you to usurp the function of the board, even if you are their legal advisor. So that kind of statement you just made is just improper as it can be. With all due respect, Mr. Weinberg, that is the province of the board members to make that decision. And I'm prepared to make the argument that I said I would make, and I have no doubt that the board will understand what I'm talking about and take the appropriate step.
So what we'll do is let each of the attorneys make their argument. Stick to the point, please. What the board really wants to know is the question of imminent threat. Is it there with enough reason for us to consider suspending a license? When that's over, we'll adjourn into executive session, discuss it, and come back with an answer.
This is executive session, Mr. Weinberg, is that?
Would that be appropriate?
Yes, my question.
I believe that it is, that actually that what the government law says is that when considering a disciplinary proceeding, they can go into, to consider, they have to come out to vote, but they can go into executive session to consider. What it says is evidence, but I guess you should consider the arguments.
Okay.
Well, you made the decision.
So here's why I think Dr. Joseph presents an imminent threat to the community. The main reason is, notwithstanding 3 court orders by the Honorable Vern Perez, a Superior Court judge, that this animal doctor from January 4th on refrained from using and administering controlled substances, and that he not use his x-ray equipment. That was clear on the 3 occasions mentioned in the specification of charges from the Superior Court judge. He has, as evidenced by the exhibits to the amended specification, as evidenced by the specification itself, when DPHSS conducted a search with an administrative search warrant of the Wiesel premises, they found records that indicate the use of controlled substances and the x-ray machine. He has violated a court order. He thinks that he is above the law. Anyone who thinks that they are above the law is an imminent threat to the community. Anyone who repudiates in terms of public safety, the only reason that Judge Perez entered this order, which conditionally renewed his license on the condition that he not use his x-ray machine and not administer controlled substances. The only reason behind that order was the safety and the welfare of the Guam community. And when you have a man like Dr. Joseph, he says, in effect, I don't care what the courts say, I'm going to keep on doing what I want to do anyway. If you're waiting for a better example of what constitutes an imminent threat to the community of Guam, I'm telling you, you're going to wait a long time. This, whatever else you think about this order for summary suspension, you will never in your lifetime, I can safely predict, see a more appropriate situation to enter that order of summary suspension. What does he do when he gets an animal into his clinic, which is obviously a pit bull terrier? He's treated this animal before, he knows exactly what it is, but he perpetrates fraud on the United States Air Force by calling it another kind of dog. And he knows that he's lying. He knows that it's fraudulent. And this violates federal law because the dog went over state lines. And you're telling me he's not a threat to the community? What are you going to do with an animal doctor who takes the dog in belonging to Joe Bamba? And he says, well, Mr. Bamba, we have to operate on the right leg.
guess what he does? He does two things that make him a threat to the community. He negligently operates on the left leg instead of the right leg, and he charges Joe Bamba for it. Now, somebody like that shouldn't be allowed to do business, shouldn't be allowed to do business and take the money from members of the paying public on Guam who want their animals treated in a competent way. Any man who calls himself a veterinarian doesn't even have enough competence to operate on the correct leg of a dog should have his license summarily suspended right here, right now, and given an opportunity within 30 days to explain himself, if he can, as to why he operated on the wrong leg and why on earth he didn't give Mr. Bamba a full refund of his money right then and there. He didn't do it. He got kicked out of Fiji because he euthanized a number of dogs he had no authority to kill, including 3 pets. Maybe that doesn't constitute a direct threat to Guam because it happened down there. But if it happened down there, it can happen here too. Now, I'll tell you another thing. I'm not going to sit here and go over every item in the specification of charges. I went out of my way to make sure you all received a copy. I'm sure you have. But I do want to say one other thing. It's not exactly like what Mr. Lujan was trying to say a few minutes ago. I don't blame him for saying what he said. It's not entirely accurate, and here's why. Since January 4th, Judge Perez has curtailed and eliminated the license of Dr. Joseph to practice veterinary medicine when it comes to 2 key aspects of veterinary practice. Number 1, he can't use controlled substances. Can't have them on the premises, can't use them, can't administer them. Without that, how can he anesthetize a dog? Without that, how can he properly treat a myriad of injuries and afflictions a pet would come in? And the second thing Judge Perez did, which attenuated substantially the license of Joel Joseph to practice veterinary medicine, is eliminate his ability to use an x-ray machine. If he wants to have an animal brought in for treatment x-ray, he has to send it out. He has to outsource that, and he hasn't done it. So what I'm trying to get at is, what are you taking away exactly? If you summarily suspend his license, which I strongly urge you to do, because you'll never have better grounds to do that, what are you taking away with you? Taking away his right to use his x-ray machine? No, Judge Perez already did that. We've taken away his right to prescribe steroids for parvo, which is another form of diarrhea. No, Judge Perez already did that. So what's left? What's left is not much, and not much is what I'm asking you to summarily suspend. I want you to totally suspend his license to practice veterinary medicine until we can have a full hearing on the merits, which the law requires within the next 30 days, which my proposed order sets within 30 days. You can set it earlier. It's up to you. I think 30 days is a reasonable interval for Mr. Lujan and myself to prepare our evidence and go forward. So you're not really doing much. He's already lost 2 key aspects of his right to practice veterinary medicine. And much of the First Amendment specifications talks about his repudiation and his disrespect for the law. As much as his negligence in the performance of his medical duties, that also constitutes a threat to the people of Guam. Over and over again, it's been brought out in testimony that he has not obtained an occupancy permit or a building permit, which the law requires. Again, if this man thinks he's above the law. Now, I want to say one more thing, 2 more things before I stop. I'll be brief. No doubt Mr. Lujan will mention at some point that Judge Bordaglio reversed the board's decision the last time they disciplined Dr. Joseph. He's going to try and act like that all of those charges that Dr. Joseph was found at fault on were thrown out. Well, yes and no. What Judge Bordaglio did, and I have a copy of his decision right here on going to make a couple of copies available in case you want to look at it when you deliberate. And you will quickly see that this 4 or 5 page decision neither directly nor indirectly even considers any of the charges that were found against Dr. Joseph last year. Those charges are unscathed. It was you, the board members, some of you who sat on that disciplinary panel and heard those 28 charges for 42 days, for 42 nights. You know, because you heard those charges, what Dr. Joseph was guilty of. Judge Balajadia didn't consider whether Dr. Joseph was guilty of malpractice, incompetence, dishonesty, any of those things that the board did consider. Those charges were never entertained by Judge Balajadia, and you can easily see that in this very short decision, which instead of talking about the wrongdoing of Dr. Joseph, not one word was spent on that. The only thing Judge Balajadia talked about was the open government law somehow violated. And he concluded there was, and because of that, he didn't consider any of the charges that this board spent, I think, 42 nights deliberating on, and found on all but one Dr. Joseph was guilty. Now that's a matter of record, and in case you don't have easy access to it, I have a copy of that here too, that your previous finding of fact. It's a matter of record. So,
I have a quick question.
yes, please.
And this could be more for legal issues as opposed to just this case. If a judge orders a provider not to use X-ray, not to use drugs, and that person continues to do that, why would it come to our board as opposed to the marshals going and arresting him? I'm confused about that.
Well, it's several things. Dr. Miller, first of all, what we did as soon as we had the evidence to do so, we filed a motion in that proceeding for an order to show cause why Dr. Joseph should not appear and be held in contempt for violating 3 of Judge Perez's orders. That motion, for whatever reason, is still pending. Now, the second thing I want to say about it is, not only is it grounds for contempt by the judge to hold Joel Joseph in contempt, it's also grounds to summarily suspend his license, because under the Allied Health Practices Act of Title 10 GCA, it's misconduct. It's professional misconduct for a licensee to defy the law of the territory of Guam, such as a court order. And that's why I put it in the First Amendment specifications charges. Does that answer the question?
Kind of. So it's, I think you, for a lot of the other board members, I think we might have a little process reversed here. So if somebody defies a court order, would that be a felony?
A felony?
Yeah. What type of
I really don't know if it would be a felony crime, but I know that it's punishable by contempt.
Right.
If he did so. I'm not a criminal lawyer, maybe Mr. Lujan better answer that question. He does a lot of criminal practice. But what I do know is that he's defied a lawful order of the Superior Court of Guam, 3 of them.
So, yeah.
And whether or not it's a felony, if definitely contravenes the standards to which a veterinarian is held to hold his license, because he's violated a lawful order of the court.
Mr. Abrams, I'm going to try and follow that up a little bit. The question of whether Dr. Joseph violated Judge Perez's order is currently pending before Judge Perez?
No, the contempt for violating.
That's what I mean. A contempt action. You filed a contempt action before Judge Perez? And so Judge Perez will rule on that question?
He'll rule on the contempt issue.
On whether Dr. Joseph is in contempt or continuing to dispense controlled substances, operate an X-ray machine.
That's correct.
Before Judge Perez.
That's correct. But
Do you have a hearing date on that?
no, we don't. But it doesn't matter. Because if this board reads the First Amendment specification and they conclude that this is enough to summarily suspend him because he's defied court orders and he's a threat to the community of Guam for doing so, then they're entitled to summarily suspend his license right here, right now.
I think that the board is concerned that
Be careful, Mr. Weinberg. You're not a board member.
I'm speaking for the board in the questions that's raised with me as its legal counsel. and I'm trying to make it clear for the lawyers. The board is concerned about its jurisdiction to make a decision about whether this Dr. Joseph has violated a court order that a court is going to ultimately decide. That's its concern.
What's your question, Mr.?
I'm sharing the board's concern. Because right now the board is saying, well, that doesn't matter within the rest of the court. For example, hypothetically, this board, if it were to summarily suspend, it would already, and then after a hearing before Judge Perez, he could decide that Dr. Joseph was not in contempt.
It doesn't matter. Even, let's say, assume arguendo, that Judge Perez heard the evidence, which he hasn't done yet. We see documentary evidence. Let's just say that after all that Judge Perez wanted to listen to and look at, he decided that it's unlikely he would, but if he did decide that Dr. Joseph is not in contempt for whatever reason, that doesn't impede this board from making its own determination. That does not prevent this board from listening to witnesses and examining evidence that would support contempt of court, and they would be free to make their own finding at variance or consistent with the decision of Judge Perez, if that happened. So far, that hasn't happened.
I understand your argument. Related to that question is if you raised the questions of the occupancy permit and the building permit. Because that's a matter within the jurisdiction of the Department of Public Works.
No, that's a matter that's within the jurisdiction of this board in determining whether a licensee has obeyed the laws of Guam, which is a condition of hold his license.
Let me ask you this question. Is there anything pending that's brought by the Department of Public Works to enforce those provisions of the law that were cited?
Well, first of all, it wouldn't matter, because this, let me just finish my answer, Mr. Weinberg.
It doesn't matter.
First of all, it wouldn't matter, because this board can make its own independent finding as to whether that law was violated. And I might also say that they've done so in the last disciplinary hearing. They unanimously concluded that he did violate the law by not securing his occupancy in his building permits. That finding was not considered by Judge Balajadia. There's nothing to prevent this board from going into that issue again and making an additional finding, whatever it might be, independent of whether Public Works is doing this or doing that. Now, second, wait a minute, I have one more thing. But don't interrupt me, Mr. Weinberg. I'm not going to allow you to talk until I'm finished.
Try and answer the
other
question.
point,
You'll get a chance to
I'm
argue,
sorry,
Mr.
Mr.
Abrams.
Weinberg. I'm still speaking. Thank you. The other point I want to make is, to further answer your question, is that there is a criminal complaint for a misdemeanor pending against Gerald Jones, filed by Carl. But I do want to say one other thing. It's not exactly like what Mr. Lujan was trying to say a few minutes ago. I don't blame him for saying what he said. It's not entirely accurate, and here's why. Since January 4th, Judge Perez has curtailed and eliminated the license of Dr. Joseph to practice veterinary medicine when it comes to two key aspects of veterinary practice. Number one, he can't use controlled substances. Can't have them on the premises, can't use them, can't administer them. Without that, how can he anesthetize a dog? Without that, how can he properly treat a myriad of injuries and afflictions that would come in? And the second thing Judge Perez did, which attenuated substantially the license of Joel Joseph to practice veterinary medicine, is eliminate his ability to use an x-ray machine. If he wants to have an animal brought in for treatment x-ray, he has to send it out. He has to outsource that. He hasn't done it. So what I'm trying to get at is, what are you taking away exactly? If you summarily suspend his license, which I strongly urge you to do, because you'll never have better grounds to do that, what are you taking away with you? Taking away his right to use his x-ray machine? No, Judge Perez already did that. We've taken away his right to prescribe steroids for parvo, which is another form of diarrhea. No, Judge Perez already did that. So what's left? What's left is not much, and not much is what I'm asking you to summarily suspend. I want you to totally suspend his license to practice veterinary medicine until we can have a full hearing on the merits, which the law requires within the next 30 days, which my proposed order sets within 30 days. You can set it earlier. It's up to you. I think 30 days is a reasonable interval for Mr. Lujan and myself to prepare our evidence and go forward. So you're not really doing much. He's already lost 2 key aspects of his right to practice veterinary medicine. And much of the First Amendment specifications talks about his repudiation and his disrespect for the law. As much as his negligence in the performance of his medical duties, that also constitutes a threat to the people of Guam. Over and over again, it's been brought out in testimony that he has not obtained an occupancy permit or a building permit, which the law requires. Again, if this man thinks he's above the law. Now, I want to say one more thing, 2 more things before I stop. I'll be brief. No doubt Mr. Lujan will mention at some point that Judge Bordallo reversed the board's decision the last time they disciplined Dr. Joseph. He's going to try and act like that all of those charges that Dr. Joseph was found at fault on were thrown out. Well, yes and no. What Judge Bordallo did, and I have a copy of his decision right here. I'm going to make a couple of copies available in case you want to look at it when you deliberate. And you will quickly see that this 4 or 5 page decision neither directly nor indirectly even considers any of the charges that were found against Dr. Joseph last year. Those charges are unscathed. It was you, the board members, some of you who sat on that disciplinary panel and heard those 28 charges for 42 days, for 42 nights. You know, because you heard those charges, what Dr. Joseph was guilty of. Judge Bordallo didn't consider whether Dr. Joseph was guilty of malpractice, incompetence, dishonesty, any of those things that the board did consider. Those charges were never entertained by Judge Bordallo, and you can easily see that in this very short decision, which instead of talking about the wrongdoing of Dr. Joseph, not one word was spent on that. The only thing Judge Bordallo talked about is, was the open government law somehow violated? And he concluded there was, and because of that, he didn't consider any of the charges that this board spent, I think, 42 nights deliberating on and found on all but one Dr. Joseph was guilty. Now that's a matter of record, and in case you don't have easy access to it, I have a copy of that here too, that your previous finding of fact. It's a matter of record. So,
I have a quick question.
yes, please.
And this could be more for legal issues as opposed to just this case. If a judge orders a provider not to use X-ray, not to use drugs, and that person continues to do that, why would it come to our board as opposed to the marshals going and arresting him? I'm confused about that.
Well, it's several things.
You'd be in contempt of
Dr.
court,
Miller,
right?
Dr. Miller, first of all, what we did as soon as we had the evidence to do so, we filed a motion in that proceeding for an order to show cause why Dr. Joseph should not appear and be held in contempt for violating 3 of Judge Perez's orders. That motion, for whatever reason, is still pending. Now, the second thing I want to say about it is, not only is it grounds for contempt by the judge to hold Joel Joseph in contempt, it's also grounds to summarily suspend his license, because under the Allied Health Practices Act of Title 10 GCA, it's misconduct, it's professional misconduct for a licensee to defy the law of the territory of Guam, such as a court order. And that's why I put it in the First Amendment specifications terms. Does that answer the question?
Kind of. So it's, I think you, for a lot of the other board members, I think you might have the whole process reversed. So if somebody defies a court order, would that be a felony?
A felony?
Yeah. What type of
I really don't know if it would be a felony crime, but I know that it's punishable by contempt.
Right. right?
if he did so. I'm not a criminal lawyer, maybe Mr. Lujan better answer that question. He does a lot of criminal practice. But what I do know is that he's defied a lawful order of the Superior Court of Guam, 3 of them.
So, yeah.
And whether or not it's a felony, it definitely contravenes the standards to which a veterinarian is held to hold his license, because he's violated a lawful order of the court.
Mr. Abrams, I'm going to try and follow that up a little bit. The question of whether Dr. Joseph violated Judge Perez's order is currently pending before Judge Perez?
No, the contempt for violating.
That's what I mean. A contempt action. You filed a contempt action before Judge Perez?
Mm-hmm.
So Judge Perez will rule on that question?
He'll rule on the contempt issue.
On whether Dr. Joseph is in contempt or continuing to dispense controlled substances operating recreation.
That's correct.
Before Judge Perez.
That's correct. But
Do you have a hearing date on that?
no, we don't. But it doesn't matter. Because if this board reads the First Amendment specification and they conclude that this is enough to summarily suspend him because he's defied court orders and he's a threat to the community of Guam for doing so, then they're entitled to summarily suspend his license right here, right now.
I think that the board is concerned that it's...
Be careful, Mr. Weinberg. You're not a board member.
I'm speaking for the board in the questions it's raised with me as its legal counsel. And I'm trying to make it clear for the lawyers. The board is concerned about its jurisdiction to make a decision about whether this Dr. Joseph has violated a court order that a court is going to ultimately decide. That's its concern.
What's your question, Mr. Weinberg?
I'm sharing the board's concern. Because right now the board is saying, well, that doesn't matter within the rest of the court. For example, hypothetically, this board, if it were to summarily suspend, it would already, and then after a hearing before Judge Perez, he could decide that Dr. Joseph was not in contempt.
It doesn't matter. Even if, let's say, assume arguendo, that Judge Perez heard the evidence, which he hasn't done yet. We see the documentary evidence. Let's just say that after all that Judge Perez wanted to listen to and look at, he decided that it's unlikely he would, but if he did decide that Dr. Joseph is not in contempt for whatever reason, that doesn't impede this board from making its own determination. That does not prevent this board from listening to witnesses and examining evidence that would support contempt of court, and they would be free to make their own finding at variance or consistent with the decision of Judge Perez, if that happened. So far, that hasn't happened. So
I understand your argument. Related to that question is that you raised the questions of the occupancy permit and the building permit. Because that's a matter within the jurisdiction of the Department of Public Works.
no, that's a matter that's within the jurisdiction of this board in determining whether a licensee has obeyed the laws of Guam, which is a condition to hold his license.
Let me ask you this question. Is there anything pending that's brought by the Department of Public Works to enforce those provisions of the law that you cite?
Well, first of all, it wouldn't matter, because this, let me just finish my answer, Mr. Weinberg, if you don't mind.
matter.
First of all, it wouldn't matter, because this board can make its own independent finding as to whether that law was violated. And I might also say that they've done so in the last disciplinary hearing. They unanimously concluded that he did violate the law by not securing his occupancy in his building permits. That finding was not considered by Judge Balajadia. There's nothing to prevent this board from going into that issue again and making an additional finding, whatever it might be, independent of whether Public Works is doing this or doing that.
That's
Now,
what the
second,
lawyers-
wait a minute,
Mr.
I have one more thing.
Mr.
But
Abrams,
don't
that's what the
interrupt me,
lawyers
Mr.
are arguing.
Weinberg. I'm not going to
Mr.
allow
Abrams,
you
please.
to talk until
Try-
I'm finished.
try and answer the
And other
question.
point,
You'll get a chance to
no, I'm
argue,
sorry,
Mr.
Mr.
Abrams.
Weinberg. I'm still speaking. Thank you. The other point I want to make is, to further answer your question, is that there is a criminal complaint for a misdemeanor pending against Gerald Jones, filed by Carl Dominguez, arising from the failure to obtain the permits. Carl Dominguez went down to the police station.
Is that part of this meeting?
You asked,
if there was anything pending.
Do you have a does DPW have any proceedings pending against Dr. Joseph with respect to the failure to procure building and occupancy permits? It's a yes or no?
There's a criminal complaint, yes.
There's a criminal complaint brought by Carl Dominguez,
As director, deputy director of the Tampa Police.
and that is pending in the Superior Court?
No, that's pending within the police station, or the 5th floor.
It's filed at the, it's filed at the
It's a police complaint.
I'm just trying to get facts. I'm not trying to argue law. I really am not. I'm just trying to understand what's going on out there that you're trying to enforce in here. Now, with respect to the controlled substance registration, is there anything that has been brought by the Department of Public Health and Social Services against Dr. Joseph on that registration as provided in the code?
Is there anything more?
Has the Department of Public Health brought any kind of administrative enforcement action on the registration that Dr. Joseph has? This is the CSR, the Controlled Substance Registration. Has the department taken any action against Dr. Joseph?
Well, Mr. Weinberg, may I answer that question? Thank you. Without interruption. Mr. Weinberg, there are two things I want to say in terms of an answer to that question. Number one, it doesn't matter because this board can independently determine in its own judgment whether Dr. Joseph should have his license summarily suspended for what is alleged in the sworn First Amendment Declaration of Charges. The second thing I want to say is I am aware of whether or not DPHSS and other agencies are proceeding against Dr. Joseph on the basis of what was taken in the search and seizure on May 8th this year. But I cannot compromise their intentions by telling you what I know about it. It's sensitive and it's in process. That's all I can say.
But it's safe to say that there's nothing been filed or nothing been initiated in any kind of administrative
Filed
action
with
at this
who?
point by the Department of Public Health.
With who?
It would be before the Department of Public Health under the Controlled Substances Act.
Filed by the Department of Health with the Department of Public Health, is that what you're saying? I'm not aware at this point of anything that's filed within their own department.
No, I don't. Move on.
Are you done?
Yes, sir.
Okay, good. Well, first, I guess I've got several arguments to make here. And the first argument that I want to make is really to ask the board to be cautious in their analysis of, the charges that have been brought by Mr. Abrams. Because you can see that as Mr. Abrams speaks, he seeks of dealing and disdain and hatred for this act. First of all, he calls him an animal doctor instead of saying Dr. Joseph. He can't even bring himself to be respectful to the man that he wants to deprive of a life and the employees that go with him. Secondly, the extent that Mr. Abrams goes, in the examples he comes up with, a lot of them just have absolutely nothing to do with, his ability to practice veterinary medicine, safely. For example, how does supposedly him lying to an Air Force guy who goes to Minnesota or whatever that state is, Air Force base, be a threat, an imminent threat to safety and health in home? How does that arise to? Or the fact that Dr. Joseph resigned from his job, his contract in teaching, and supposedly breached that contract in teaching that has absolutely nothing to do with Guam. So he receives, Mr. Abrams gets a letter from some person in that organization in Fiji that says he breaches contract and, left us hanging. So how does that breach of a civil contract have to do with, it arising to being a threat of imminent danger to health and safety? Or, the other thing that you have to analyze when you decide whether to give credits to Mr. Abrams' statements is that Mr. Abrams, in his hatred for Dr. Joseph, has now reached several duties that he has as an assistant attorney general in his desire to prejudice you against Dr. Joseph. He has now disclosed, he says, I can tell you that the Department of Public Health and Social, or whatever it is, DPHSS, has instigated an investigation. But I can't tell you the details. Guess what? The cat is out of the bag. And why has he done it? He knows he has an obligation, even if it were true that he is not to disclose investigations ongoing, especially if they're criminal. He has now disclosed, and why do you think he did that? Because he wants you to see, when you look at him, this is a really dangerous man. He now tells us, in response to Mr. Weinberg's question about Department of Public Works. Oh, but doesn't matter. Besides, Carl Dominguez has filed a misdemeanor complaint, even though there's no criminal case yet. He has disclosed it. It's a complaint with, he said, with Guam Police Department. It has not even arisen to a criminal case, because Mr. Abrams knows, in order for it to arise to a criminal case, someone in his office must file a magistrate's complaint and file it in the Superior Court of Guam. Then you have a criminal case. In the meantime, guess what you've got? Nothing but allegations or accusations that do not necessarily merit belief. He complains that, I believe, Dr. Joseph has breached Judge Vern Perez, orders, and he has filed an order to show cause. And he has filed it, but guess what? There's been no hearing. No hearing yet. Well, if it was such a big thing, if it was such a grievous offense, a grievous breach of Judge Perez's order, then why has Judge Perez not scheduled a hearing? Why is he not in a hurry to schedule a hearing so he can deal with this recalcitrant animal doctor, as Mr. Abrams says? Isn't that the best proof that you have a sitting judge who has heard this case, for months, and is well aware of the allegations against him, that he is not in a hurry to rule on it? Isn't that the best proof you've got that there is no threat to imminent danger or safety? That's the best proof that you've got. He talks about Judge Bordan. And he says that Judge Bordalo ruled and, you know, overruled your decision and everything. And Judge Bordalo, though, you know, he didn't reach the merits. He only ruled on, well, was the Open Government Act violated? Okay. And Judge Bordalo, you know, threw out your decision in which that, you know, took 42 days of hearings. Well, my understanding, first of all, is it was 13 days. But you folks that took place here, rather that participate in it, know the truth. Is it 13 or is it 42? If it's 13, then you can see the venom coming down out of, you know, from Ben's mouth, you know, that poisonous venom, because it's designed for one thing, to prejudice you folks against Judge Bordalo for overturning, you know, your decision, and to make you, you know, hopefully rule tonight against Dr. Joseph. Now, I guess the other question I have is, how does this board deal with things that are occurring in court? Mr. Weinberg is correct. Why should this board, and I believe Dr. Miller, why should this board deal with things that are in the Superior Court? Since when and why should this board deal with things that, you know, are alleged to be violations of DPW or DPHSS? This board is not a board for everything. This board, you know, has enough to do that it can't listen to the ranting and the ravings, you know, of an assistant attorney general that is obviously out to get Dr. Joseph. So, and the other question the board has to ask, how can this man come before this board and say, I want you to summarily suspend his license? What license do you folks have to suspend? You think you have the power to suspend the license that was issued by Judge Vernon Perez? Judge Perez allowed him by court order to practice, you know, to continue practice in December of 2012. Since when do you have the power? Notwithstanding Mr. Abrams' advice to you, so-called legal advice. Since when do you have the power to overrule a, you know, Superior Court judge's order? You think that by saying we summarily suspend his license, that judge, you know, Vern Perez is going to issue an order saying, aha, Dr. Joseph, guess what? I've been overruled. You're not practicing anymore. He's asking you to engage, you know, in a futile act, and that is to do something that you do not have the power to do. Now, talks about this dog, about, I believe, owned by Bamba and Mr. Bamba. I guess the question is, you know, when did this occur? Okay? If he refused to return the money to Mr. Bamba, there is a solution to that. Mr. Bamba goes to small claims and files a small claim case. Huh? Oh, in fact, he's already done that. The hearing is August 30th. But let me ask you, how is that an eminent threat, you know, to safety and health? How is not paying $50 or $200 or $600 a threat to that? Now, Mr. Abrams says that, and I believe I've addressed He's talked about the occupancy permit. He's talked about Mr. Bomba, about Judge Bordalo's decision and order, me not on the dog, teaching, DPHS, DPHSS, at discussed. And he then says, well, I won't go into the other charges. Well, guess what that means? My understanding is there's 17 charges. And I could be wrong, could be more. But whether it's 17 or 27, he's only addressed 6. And I believe that he has either weighed those specifications by, not arguing about it and saying I won't go into it, or abandoned it. But in any event, I believe that those are not on the table any longer. So, I guess our position is that, Mr. Abrams has not carried his burden to allow you folks to make a decision summarily suspending Dr. Joseph's license. And again, like I said, even if you folks wanted to, I don't think you've got the power. And anyone who says that you can overrule a judge, believe me, send him to the mind doctor, because he's wrong. Thank you.
I would like to just say a few words in rebuttal for all of that. That's very good. I always enjoy listening to Mr. Lujan and observing his emotional tactics. What I'd like to say, first of all, is you're not overruling Judge Perez. Judge Perez ruled on renewal only, just renewal. So his license was conditionally renewed. What's left of his license means that he's still a licensee, doesn't it? Of course it does. He's had his license conditionally renewed by a judge, but that license was issued by who? It was issued by the Guam Board of Allied Health Examiners. So under the Allied Practices Health Act, you have the power to sanction and discipline and suspend the license of any licensee, regardless of how his license is renewed. Judge Perez didn't renew his license and say, well, I'm renewing his license, and that means that he can violate any of the conditions that a licensee is expected to adhere to under Title X. He didn't say that, because that would be ridiculous. Having his license renewed, condition, whatever's left of it, either by the board or by Judge Perez, means the same thing. It means that he's a licensee, and as a licensee, he has to toe the line. And he has flagrantly violated the conditions of his having a license by his total repudiation of the law, by violating Judge Perez's order, three orders by Judge Perez, and violating the law by not getting an occupancy in the building permit, violating the law by misdescribing intentionally and fraudulently, saying a dog is one breed when he's clearly another breed, and goes down to Fiji and unauthorized killing of animals and pets down there. There's so many reasons why Dr. Joseph is a threat to the community, an eminent threat to the community. And, it's not like we haven't heard a lot of these charges before. Some of you were on the last board that adjudicated this matter and heard compelling evidence, and the board voted unanimously in support of charges that included failure to get an occupancy permit in the building. You've heard the evidence. Judge Bordalo didn't disturb any of that. He just ruled on something totally different, which is the open government law. So there's no disturbing of those findings by Judge Bordalo. He threw them out because the open government law was violated. But on the merits, that's still valid to consider.
I heard Mr. Lujan talk about whether I hate Dr. Joseph. You know what? I don't hate Dr. Joseph at all. I find him disgusting, and I find him a quintessential example of a licensee who has violated the terms of his license. The way he cheated Joe Bomber by operating on the wrong leg of Joe Bomber's dog and then charging him for it. If that's not a threat to the paying public of Guam, an imminent threat, can't imagine a better one. And the negligence, how would you like to take your pet into an animal doctor who has operated on the wrong leg of somebody else's dog? You gonna feel okay about that? And to allow a man to continue to use his license and do this again and again, that's gotta be an imminent threat to the paying public of Guam. And that's my interest. As an Assistant Attorney General, my job is to protect the public interest. And when I see licensees such as Joel Joseph flagrantly violate the conditions of his license, I have no hesitation in urging you to see that that's an imminent threat to the welfare and the safety of this island, and to summarily suspend his license. Now, I didn't go into all of the charges in the first specification. I hit the ones that I thought I should explain more fully. But I didn't back off from any of those charges. They're all before the board. They're all in the first amended specification. And every last one of them are valid. And every last one of them are enough to summarily suspend Joe Joseph's license. And unless there are any questions, like a board member, I'm ready to submit it to your endeavor.
Are there questions from the other board members? If not, I think the next order would be for the board to go into executive session and discuss.
I guess that's true.
Okay. So Marlene's your place for the meeting.
This place here, if you're gonna declare an executive session. Is this the only place?
You know, may I say something? I'm not sure, I don't practice much before boards, you can tell. This is my second time really before a board, you know, from last night. But, and I could be most likely mistaken, but I believe that if we're going to go into executive session, is to be considered that there has to be notice. Like I said, I could be mistaken. And if there has to be notice, then obviously we have to. Since there's been no notice.
There are not many things that Mr. Lujan and I agree on, as you can see. But I also have mixed feelings about going into executive session. I remember at the conclusion of the last disciplinary case against Joel Joseph, the board deliberated in a public way with the public present. I could be wrong about this, and I'm not trying to overrule what Mr. Weinberg wants to do, but I think in the interest of the public knowing what the board is doing and why the board is doing it in an executive session is the wrong idea. Now, I'll defer to the board's preference, but I think that public right to know how the board arrives at its decision and what its decision is, in my opinion, and I'm not board counsel, but that outweighs the need for an executive session. And if I were to vote on it, I'd say deliberate before the public and arrive at your decision in a completely transparent public manner. That's just my opinion.
No,
I say, Mr. Lujan, I don't agree on everything, but
Well,
you might agree on
I don't think we still agree. Because I'm not saying they can't go into executive session. I'm simply saying there's a step that they have to take before they go. That's all. That's what I'm saying. So, because I don't know the state of the law really with executive session. But I'm one of those people that believe that, people that function as judges, and boards do function as judges, I believe you have a right to go into executive session to discuss it. But they can't make a decision. They have to make the decision openly. They can discuss
Whatever-
the merits,
whatever it
whatever it
turns
is,
out.
but don't decide.
Whatever it
Mr.
turns out to
Lujan,
be.
I think I have the answer to what I think you're referring to. And I think what you're referring to is section 8.1.1.C, which talks about the board going into executive sessions to talk with its lawyer about impending legal matters. Yeah, this is in Title 5. It's the Open Government Law, this section. Yeah. And this is not what the board is doing here. It's going in under the section to, it's not going to consider like a legal action in which the board is a party. It's like if I'm going to have it and I want to invoke attorney-client privilege, and in that case, I have to sign something in advance. I have to sign something afterwards that swears that we only talked about this litigation, and it has to be transcribed, or it has to be recorded, and it's subject to being transcribed 6 months after. And that's not what this section is.
Well, I put on the record. Thank you.
Yeah, I did review that. I agree. I don't think that this is appropriate for executive session. So I think we should deliberate if they're going to make a decision today. In open.
Oh, in open.
In open.
I think we should arrive at a decision, and out of an abundance of caution, I would go along with Judge Cease.
As your hearing officer, I'm able to give you advice as to questions. Right? So here's my impression of the proceedings. I do believe that this board can revoke or suspend the license. Okay, so, and if they don't like the decision of this board, they can take it up with the decision made by this board. Now, the only thing before you, according to law, is to in making a decision as to suspend a license, you will have to look at whether everything that Mr. Abrams said does prove that there is an imminent threat to public safety. Okay, so you got to look at the minds of the legislature. I don't have case law before me right now. You look at the minds of the legislature, whether this is the type, these facts as presented to you regarding violations of building codes, unlawful use of x-rays or controlled substances, and possible negligence to animals is something that the legislature intended to fit within something that is an imminent threat to public safety. So when making your decision, I think that's the only thing that you have to decide on based on what the arguments are here today. I think imminent is an important word here under the law. That's my advice.
Well, I would just point out, that same section that talks about summary suspension also provides that the court will not interfere with that decision.
I don't think, I do object. I believe that you folks are now operating a deliberation thing. I think Mr. Abrams tonight should say that.
I'm just saying what the law provides. It does, Mr. Greenhouse, have that provision.
That's why.
You see, there's something in the summary suspension section which does state that if summary suspension is ordered, that the court will not overturn or interfere. I forget the exact word. It's in there, and I think Mr. Weinberg knows about that too.
I think Mr. Abrams has finished his arguments and he can continue, trying to influence the deliberation.
All right. So we can open the discussion to the board member, or like to start. Does anybody have anything they'd like to say in relation to this?
Are we able to consider issues that are before the court but not yet been resolved? For example, he said that there's an order to show cause for contempt for violating the 36 code order, which is before the court, but that has not been ruled out. So the question is, can that even be considered?
Well, the argument was made by both attorneys. So that's actually probably one of my gut feelings in this particular case is we are being asked right now to pretty much use one of our most powerful tools. Yet we have, in my opinion, unanswered questions. Is he in contempt of court? I don't know. I really don't know.
Well, even if he is that pose an imminent threat to public safety? You gotta
Right.
keep looking at it.
Well, that was one of the arguments, though, is that somebody who would knowingly be in contempt of court would be a threat.
Would it pose an imminent threat
Would pose.
to public safety? The fact that it's true that he violated the court order.
Right, but we don't know that yet. What I'm trying to say is my gut feeling as a board member, acting chair, is to be proceed with probably extreme caution, simply because this has been going on for a long, long time. None of us are lawyers. They're on board. Most of these arguments are eloquent, somewhat frustrating to listen to because I don't always understand them all. And the way that the legal system works. So my gut feeling is at this time, we don't know if he's in contempt of court. We don't know what's going to happen with Public Works. And if we were to hang our hat on those issues, and those issues didn't prevail, say he wasn't in contempt of court, issue with Public Works didn't prevail on that, then we're back to square one. So my gut feeling is we simply don't have all the information at this time. I think the charges are very deep and concerning. You know, we want all our licensees to be good citizens, but we need the information to proceed. And I'm afraid there's the issue of being a threat. There's quite frankly the issue of the board itself is we continue to proceed and then we continue to get reversed. We're not getting it. So if we proceed with caution and let these other things go before Judge Paris, the other issues before Public Works. The way I would like to see it work is, you know, we have in our rules and regulations that if he's found guilty of a felony or those things, then they have to report that to the board, and that could be an issue that could cause a non-renewal or suspension of license. But so far, we don't know that yet. And it kind of seems to be getting the cart before the horse. Is there any other discussion? Yeah?
Well, I'm going to echo a lot of what you're saying there, Greg. A lot of what I see in these specifications of charges, and again, having sounded on these things in the past, some very serious charges, and yet they're being decided by relative laymen in terms of law. And I feel that if whoever's doing the investigation of these charges, or for that matter, the Attorney General's office, feels that they have very strong case on these sorts of serious GCA violations and USC violations, that should be taken to the appropriate court that handles GCA violations and the appropriate court that handles USC violations. And if there are charges there that have enough merit to stand up in a court of law and be decided in a court of law, then the result of those charges, yes, can be considered by us. But I don't think we should be deciding what has the merit and the standard of proof of a court of law. That's my opinion.
I just want to say that what do we do with these people that are writing letters of concerns or letters of complaints? We have Mr. Balajadia, and I'm not sure what the gentleman is with regards to law, but here there are complaints that are written and submitted to the court. Really ignore those.
Actually, from what I understand, no, because this particular hearing is just about summary suspension. Everything else continues to move on. So I would imagine sometime in the future, a series of hearings about the charges themselves.
We need to set a date on the merits where the lawyers can present evidence. And next stage. All you're deciding if this is whether to suspend Dr. Joseph's license between now and whenever. It would have to be within the next 30 days. It's a temporary suspension now, pending full-blown hearing on all of the charges, including the allegations about the church was involved. Makes sense?
I guess the question I have is, we're gonna if we decide to suspend, are we overruling Judge Harris's? So that's not